the petitioner has not established by clear and convincing evidence my wife found puppies for sale. I had to tell her that that probably wasn't a good idea. So either the court was going to say, yeah, I effed up, and the petitioner didn't carry her burden of proof, or the court was going to say, yeah, I fucked up, but I'm going to pretend that the petitioner carried her burden of proof because I really want to grant this particular petition. So I prepared. I well prepared, and I spent a couple hours of the client's money making sure I had case law on point. And I wouldn't necessarily mind another rescue, but we're not buying a puppy. Showed up at the hearing. Client was incredibly distressed. You know, the judge starts going through her spiel. I'm in the country. I could have as many dogs as I want, as far as I know, but I'm not trying to become a collector. The court does her spiel, and I've asked, by the way, prior to the court starting her spiel, for a statement of decision, and then she says 3-year statute or a 3-year restraining order. And I started asking her, well, Your Honor, what about the no legitimate purpose? All these texts which you found to be harassing, they were all from my client, who is a single parent, has sole custody of his child, and he was texting to find out the location of his child, who's supposedly with this person. Are you suggesting that's not a legitimate purpose? And about a half hour of argument later, the court changed her mind again and denied the civil harassment restraining order. And I just sit here wondering to myself, if that client had not been represented, for all the terrible stuff that attorneys do, if that client had not been represented, that client would have been railroaded into a civil harassment restraining order, a 3-year one. He would have lost his right to own, to possess firearms. And man, it's just so frustrating. Like, why a court would do that. Anyway, that's the end of story time. So we're going to start off with a little bit of Pierattini. Something I noticed is that Paul Katrinak of the law offices of Paul Katrinak, who represents the defendant Michael Pierattini, is no longer running his own law firm. He has joined the Kernan law firm. A more junior attorney is now his boss, and now he's representing plaintiff and cross-defendant John Rowe. Okay, bro. Oh, Jesus Christ. All right. So this is the first amended answer. So there was the initial answer, and it was just a general denial because Chile did not do a verified complaint. Move that here. Yeah, the higher number is a younger attorney. My number is in the 300,000 range. So this attorney with the 747 is a elder attorney to me. So so there was a general denial, which is fine because Chile didn't know how to do a verified complaint or chose not to. And in the initial cause of action, there were I'm going to say generously 19 affirmative defenses. It goes 18 and then back to 14. And 14 isn't really an affirmative defenses, is not really an affirmative defense. It's a garbage, non-pled, non-pleading. It's stupid. The correct approach is if you do find a new affirmative defense, you ask the court to for leave to file an amended answer so that you can plead a new found affirmative defense. That's the correct thing to do. Well, anyway, you don't see this. You don't see this here. There's the 18th and then the 14th. That's garbage. All right. So the court issued a ruling on Chile's initial demur motion to strike, or motion without motion to strike. Chile demurred to Pierattini's affirmative defenses, and the court denied it as to Pierattini's first affirmative defense. That was the failure to state facts to constitute a cause of action. And that was appropriate. Got to show this one. But then as to the other ones, as to the remaining 17 or 18, depending on how you want to count it, the remainder of them were sustained, right? So overruled as to number one and sustained as to the remainder. So the question then becomes, what did Pierattini do? What did Pierattini and or Pierattini's attorney do? Well, he filed a new answer working for S. Michael Kernan. I wonder if I should be like J. Emerson Rietveld instead of like John Emerson, like in John E. Rietveld. All these other attorneys seem to be doing the first name as a initial. That must be what the cool kids are doing. Maybe I should be J. Emerson Rietveld. So anyway, here's the second amended complaint or amended answer. Again, general denial, which is absolutely fine. And then affirmative defenses. The first one is fine. We know that. But then the second one is failure to mitigate damages. Now you're going to say failure to mitigate damages. Is that new? No. That was initially count 5. Show this tab instead. Count 5. Or the fifth one. Failure to mitigate damages. Which the court has already ruled on that you need to provide actual facts. You have to plead actual facts to show failure to mitigate damages. But what did he do? He did not provide any facts. He just said, defendant alleges the First Amendment complaint and each purported cause of action against defendant. Nope, hold on a second. As a second separate and distinct affirmative defense, defendant alleges plaintiff has failed to exercise reasonable care and diligence to avoid loss and minimize plaintiff's alleged damages. What has he done? Specifically, what has he done? No. My grandmother, my father's mother, liked Ralph Waldo Emerson. And so she named my father, she gave my father the middle name of Emerson. And all the cool kids do it. But anyway, she named my father John Emerson Rietveld. And then my father, I guess because he thought he was really cool, named me John Emerson Rietveld II. So, All right, so I'm going to answer some of these. Ralph has a lot of questions, and we're going to just go through these real quick. So, in this country, a person as dumb as Shirley can make someone waste their life savings. Even the lawsuit is a joke. If Kate spent 50K on her lawsuit with him, the country needs to change things. No, you have a First Amendment right to petition your government for redress of grievances, and that right does not extend only to smart people. It extends to everybody, including you, Ralphie. You have a right to petition your government, i.e., file a complaint or a petition with a court seeking redress of grievances, asking the government to fix the problem. You have that right. Chile has that right. And unless someone abuses the system, then they get to continue to exercise that right. So, no, you're wrong, sir. So, Chile will get away with this. Get away with what? He has filed a complaint. He may or may not prevail. I doubt he will prevail. He has not shown any indication he will prevail. So, how do you know? How do you know he'll get away with it? If by it you mean he is causing Pierattini to spend money, well, no, he's not, because Pierattini could have done the Kate route, which isn't necessarily a bad route. You could just default. Chile still has to prove to the court that he was harmed, that you are the cause of that harm, legally and proximal. You're the legal and proximate cause of that harm, and that it cost X amount of damage. Chile has still to prove that. How can someone countersue Chile for all the money he makes through YouTube and his store? Well, they can file a lawsuit, just like Chile filed a lawsuit. Now, you wouldn't sue specifically for that money. That's not, no one has a particular right to that particular money, but they would be able to sue for money damages generally. Now, again, do they have a cause of action? Probably not. You haven't stated one. I don't know. How does the court not say, period, this guy's an idiot and this lawsuit is a joke? Question mark. Well, it has to get in front of the court. That's what a motion to dismiss is about. That's literally what a motion to dismiss is about, or a motion for summary judgment. That's where you say that there's no cause of action here. That's how it gets in front of the court. The court doesn't sua sponte do that, because that's not the judge's role. Until it gets to trial, the judge doesn't have to make a decision on that unless one of the parties moves to dismiss or for summary judgment or something like that. This entire lawsuit, says Ralphie, is, and the way Chile is abusing it is laughable. The country needs to change things. Well, Chile thinks that he was abused. Chile thinks that he was wronged. And Chile is petitioning his government for redress of grievances. And that is the appropriate mechanism. You don't go fight someone in the backyard or on the street. You file a lawsuit against them. You ask for injunctive relief. You ask for monetary damages. You ask for those things to make you whole. And you disagree with Chile's analysis of Chile having a cause of action or not, but you have the right to disagree. The defendants have the right to disagree. And the person who gets to decide is the judge, if and when it's appropriate. Why does Mike or Kate just sue Chile? They haven't sued Chile. They have more of a case than he does. Well, state your cause of action, attorney Ralph Clifforetto. State the cause of action. Oh, you don't have one because you're fucking stupid? I thought so. Why doesn't Chole just take these phony suits to Judge Judy or one of the other ghetto shows? Well, because Judge Judy or one of the other ghetto shows would have to, A, want them, and B, all the parties would have to agree to them. Yeah, but can take advantage of it. I don't know what that means. This seems like a joke to me. I would countersue him. First, the stress he caused me with the lawsuit. Well, I'm going to interpret your nonsense statement as a countersuit for malicious prosecution. Well, you would have to show that he was suing you frivolously, and I don't know how you would be able to do that. The stress Chile causing Kate and Michael. Like, how do you know he's causing Kate stress? How do you know he's causing Pierattini stress? You're being silly. All right, now that we've gotten that nonsense taken care of. All right. So, long story short, he has pled. He dropped latches, estoppel, waiver, statute of limitations. He dropped those 4 causes of action as
Chile admitted it on the live stream.
Okay. Does that mean that none of his causes of actions have any validity to them? You can sue for a variety of reasons. He admitted he was just wasting their money. I would show that video and boom, I win. Well, you know what? Here's something funny and kind of stupid, Ralphie. Um, you're a fucking idiot, and the actual attorneys haven't just showed that video and proved it. You fucking douche. Shut up. You're a fucking idiot. You're about as smart on the law as Chili is. Dumbass. Why do idiots come into my stream and start talking like they know what the fuck they're talking about? Douchebag. Go neck yourself. Hold on a second. Nah, you are poor and not a good lawyer. Okay. Just the fact that I've been right all the fucking time in predicting this shit. I'm just a bad lawyer. I'm poor. This motherfucker seen my bank account. I'm poor. Jesus fucking Christ. A poor lawyer. Yeah. Is that an oxymoron? I don't know, bro. What an idiot. You're poor. You can't trust what I say. I'm a lawyer. I could have just lied about that. You don't know. You don't know. All right. Anyway. So he dropped several affirmative defenses, and I think that's kind of fun. He dropped latches. Latches means that that Chili waited too long, and he didn't. While he may not have waited past the statute of limitations, Chili waited to allow things like witnesses to go away, and it unfairly prejudiced the defense. Now, you'd have to actually plead facts for that. I could understand how that'd be hard. Estoppel. There are different kinds of estoppel. What kind did he plead? He pled as waived as otherwise has stopped the pursuit. Well, I don't know what the fuck. There's estoppels like where you've already. I was asking questions. No, you weren't. You were making assertions. You were making positive assertions. You weren't saying, "Hey, could he do this?" You were making assertions. Let's see. You are poor and not a good lawyer. That's an assertion, not a question. Chili admitted he is just wasting their money. I would show that and win, and boom, I win. That is also not a question. That is assertion. Chili admitted that on live stream. Again, not a question, an assertion. The stress causing Kate, Chili, and Michael. Again, that's an assertion, not a question. This seems like a joke to me, period. I would countersue him the first stress he caused me with the lawsuit. That, again, is an assertion, not a question, you stupid fucking moron. Why acting like a cunt? Why are you acting like a fucking idiot? You are making fun of me. You figured that out all on your own? Everybody, one in chat to give Ralphie a round of applause for figuring out that I'm making fun of him. Jesus, Ralphie, you fucking idiot. Oh. So, round of applause. Round of applause. Round of applause. Thank you. Thank you, Ralphie. You're a fucking idiot. All right. Where were we? So I don't know exactly what kind of estoppel. There's collateral estoppel. There's different ones. So I don't know what kind of estoppel he was pleading there. So it's hard to say exactly what he was saying, what he was pleading. Waiver. He waived rights. I don't know what the fuck he's talking about. Waiver. Statute of limitations. That was pretty explanatory. Yeah. So anyway, those are the ones he dropped. But every single other one that he put in the new one, every single other one, share this tab instead. So, so the second one, failure to mitigate damages. Failure to mitigate damages was the fifth affirmative defense in the first one. He has not added any facts. Unclean hands. Unclean hands, you have to come to a person seeking equity has to come with unclean hands. Typically speaking, like if you go in there preventing the person from doing the right thing, you can't you can't go in and say, I want equity. I want the court to give me this thing because, and it's an equitable defense. I can't ask the court to give me something because I'm the one who kind of caused them to not be able to follow through with what they were supposed to do. Is Rekieta a bad lawyer? I watched Mr. Medicare, and apparently Rekieta like got catfished by a trans person. We're going over. This is the attorney's work, and I use the word work loosely. So yeah, I guess Rekieta got catfished by a trans person and was singing that person love songs or something. So I thought that was funny, but I don't watch Rekieta. I don't know if he's good or not. My house doesn't look nice. Well, I'm sorry. Yeah, it was that. It was bad. God, I love Mr. Medicare. Well, I don't really care, dude. Like, I don't really care. This thing right next to me is an antique. God, it was expensive. I don't remember exactly how much. I paid for it in cash. The aquarium behind me is a low iron rimless tank. It's a 120p. I mean, the lights above it. There's 3 canister lights. Those are like 100 and some odd bucks each. The strip light's a Fluval 3.0. That's like a 4 foot long. I don't know. Yeah, it's not. That's cheap. These are cheap. Well, okay. I mean, I guess everybody has their thing. I mean, if you're if that's cheap to you, then all right. Okay, seems to be an okay lawyer. Not a lot of shit on his spurs, like potentially criminal. I don't know exactly. I don't know. I don't watch Rekieta or potentially criminal, so I don't know exactly. I don't know. I don't know exactly what you're trying to say there about potentially criminal. Anyway, so anyway, all of the new affirmative defenses were old affirmative defenses. He just removed 4 of them, and so they're off by 4. Like the 14th affirmative defense, the first 14th affirmative defense, punitive damages, would be the 18th affirmative defense in the original complaint. There's 18th punitive damages unconstitutional. So essentially, what I'm saying is that the court has already said that the demur was sustained as to those. So he had to plead. He had to plead that he had to plead facts. Now, in some of these, I don't actually know if there are facts that you can plead, like no malice, suppression, or fraud. That's kind of hard. That's kind of hard to plead that you didn't do something. Failure to state a claim for punitive damages. Ralphie, I'm just a first-year family law attorney, so you can't expect me to have a lot of high-end, expensive stuff. And yeah, money isn't everything. I have people like you to make me feel better about myself. I get to compare myself to you, and that makes me feel good about myself. And I like that. You like Kate and Mike? Well, Mike's a piece of shit. Kate is also a piece of shit, but she has big titties. And I like Kate. And I'd hang out with Kate. I'd take Kate out to dinner. Yeah. Oh, if you knew how much money was in that fish room. If my wife knew how much money was in that fish room, she would probably castrate me. But if you only knew. So failure to state a claim for punitive damages. I don't know exactly why he would have to plead facts on that, but the court said he did. Where are we at? So no malice, oppression, or fraud. I don't know how you'd plead facts on that. Failure to state a claim for punitive damages. I don't know how you'd plead facts on that. Communications Decency Act. You should be able to state facts that would show that what Pierattini did or didn't do applies to the Communications Decency Act. Now, if I remember correctly, and I could be wrong, the Communications Decency Act allows internet content providers, internet platform, like it allows places like Google and Twitter and those kind of things to moderate content without being sued for it, like to prevent people from posting things. And it allows users to block things. And I think it also allows does it allow users? Is that the one where a user can no, that's not it. You can't repost. I think it just allows you to block stuff. Allows you to moderate stuff. So if someone posts on my channel, I can delete their post without being sued for it, if I remember correctly. And if YouTube doesn't think that someone's post on my page is appropriate, then they can. That's what I think the Communications Decency Act allows. So what he should do is he should plead facts that show why the Communications Decency Act applies to what Pierattini allegedly did. No damages. I don't know how you'd plead facts on that. No damages is just saying no damages. It's like failure to state a claim. Statements were true. I think he should state specifically what statements were or were not true, and show evidence that they were true. Like state facts, not evidence. State facts to show they're true. Protected opinion. I think you should identify the opinions, specifically that identify the statements that Pierattini allegedly made that were protected opinion in there, and then state why they were protected opinion. First Amendment, again, state the various statements that Pierattini made and state why they were protected by amendment. I do like Kate. It's weird. I don't know what you're responding to, but it's weird. People like, she's a liar, she's a bad person, how can you like her? Well, I mean, show me the perfect person, first of all. Like, I'm not perfect, you're not perfect. Holy Jesus. Oh my God. Like we've got another Ralphie. Whoo. But yeah, I like Kate. I mean, I'm not saying I'd trust her with my PIN number on my ATM card. She is an admitted liar. She forged documents and presented them to Google as if they were true. There's some other things out there that she has not been entirely truthful about. But that doesn't mean that everything she says is a lie. I would, verify what she says. But I like Kate. I don't like Chili. I don't like Turtle Boy. But that doesn't mean that everything that they say is like, just because me liking them or not liking them has nothing to do with whether or not they lie or they tell the truth. It, like, again, you can compartmentalize certain things. So what's the next one? Offset. So Offset, I think you'd have to have a counterclaim. Offset's typically more like if X owes me money and then X sues me, I could say, well, you owe me this amount of money. But I think that'd be better done in a cross complaint. Misjoinder of defendant, you have to say why, which damages you're not liable for, why you were improperly joined. And I don't think he's really joined. Plaintiff at fault for any alleged damages, you'd have to say why. Unclean hands, you'd have to say what Chili did that, and you can't just allege bad things. Like, you have to actually say, like, how Unclean hands has to directly relate to the relief that the plaintiff is seeking or the petitioner. So unclean hands, it'd have to be like, you can't just say, well, Chili's a bad person. You have to say what Chili did that prevented or caused the defendant to do the bad that Chili's complaining about. Failure to mitigate damages, you'd have to say what kind of damages Chili had, and what Chili should have done and what Chili didn't do. And then obviously the first one, the court's already ruled that the first one is the failure to state facts to constitute a cause of action. That's perfectly valid. So Chili has you eat beef and sausage by the ring truck load. I don't even know what the fuck that means. I like beef. I like sausage. I don't know what a ring truck load is. Notice of hearing on demur. So this is Chili's notice of motion and motion. So he's demurring to the amended answer. So she should say amended answer. Yeah. Demur to all affirmative defenses and prayer for relief in the answer. Plaintiff's demur was technically due January 15th, 2024. Was it? I got this specifically to find that out. 20 days leave to amend. 20 days from the date this became final. This appears to be December 5th, so it should be the 25th. So it does appear that it was filed late. However, it's been filed, and Chili didn't take a default. So, all right. So it's technically due January 15th. Was it though? I thought it was. Hold on a second. December 5th. 20 days would be December 25th. Maybe I'm wrong. What am I missing? What am I missing? Oh, yes, he does. I time out, Tim. I time out to give people time to think about it. At least on here. Yeah, he get a timeout if he's not. So what gets you timed out is being disingenuous. I think Ralphie's just stupid. I don't think he's disingenuous. Well, so there's court days and there's calendar days. And 20 days to me would be calendar days. If it's calendar day, 20 days is 20 days. If it's court days, then you exclude holidays and weekends. So, but normally you'd have to know you're not blocked. Hi, Scott. So I don't know. I don't know how I got there. Maybe I'm wrong. Maybe I'm dumb. Maybe it's Maybelline. So he says the demur was technically due January 15th. However, he filed this demur late due to a failure to substantially. Oh, plaintiff's demur was due January 15th. Okay. So when was this filed? Do you have 10 days? You only have 10 days? That doesn't seem right. That doesn't seem right. Let's see. CCP, civil actions, and pleadings. Time to respond. Mm-hmm. I never remember where it is. Where is it? Where is it? There we go. Uh-huh. Provide 430.30. So let's go to 430.30. Ten days. 10 days after service of the answer. There we go. All right. Sorry about that. So 10 days after service of the answer, and this was served by email January 2nd. Email adds 1 day, right? Let's see. I think email adds 1 day, unless I'm mistaken. And that would be Code of Civil Procedure. Code of Civil Procedure. And that is 1014, I think. Let's go down here to 1014. Notice filing service of papers 1000 and 13, 13A, 13B. It's not 14. It is. Oh. It's this huge long one. That's what she said. 10.6. There we go. Shall be extended 2 court days. 2 court days. All right, so 2 court days. So it adds 2 court days. And so January 2nd plus 2 court days. So you'd have 10 days. January 2nd was a Tuesday. Is when it was served. So 7, 8, 9, 10 plus 2 court days, 1, 2. So it would have been due on the 16th. Am I counting that wrong? 1, 2, 3, 4, 5, 6, 7, 8. Oh, Jesus. 2 court days. So it's 10 days plus 2 court days. 10 days plus 2 court days. So 10 days, 7, 8, 9, 10. That's the 12th, Friday. And then 2 court days. So it would be Monday and then Tuesday. So it would be the 16th. All right. Ralph, I'm going to say it again, slower this time, and hopefully you understand it. Most defendants are going to think that a lawsuit is a waste of the court's time because most defendants don't think they're liable to the plaintiff. Most plaintiffs do think that their case has merit. That's why they filed it. So who is going to make the determination and when that a case lacks merit? The court does. When does the court do it? There are 2 times when a court can do it. Number 1, when a defendant files a motion to dismiss or a motion for summary judgment or demur, something along those lines, where a defendant places it in front of the court. The court doesn't sua sponte do it. A defendant has to place it in front of the court. That's step one, or time number one. Time number two is at trial. If the plaintiff can't prove his case at trial, that's the second opportunity the court has to get rid of a frivolous case. So unless and until the defendant places it in front of the court isn't going to get rid of it. So the question you need to ask yourself, Ralphie, is why hasn't the attorney placed it in front of the court yet? I don't know. Can I answer that question? What, instead of like having a bar fight over it? There's a reason why we have the legal system we do. You have to prove your case. No, it will not hurt him. It doesn't matter that he said that. What matters to the court, the only thing that matters to the court, is whether or not he has a valid cause of action, that he's properly pled that valid cause of action, and that he can prove that cause of action. That's all the court cares about. The court doesn't care about why. You could bring a lot. If someone wrongs you for $10, you could bring a lawsuit for that $10. Now, you might not need that $10. You might just be bringing that lawsuit just to piss off the person. And they can't say, well, Your Honor, you should throw this out because the only reason he's bringing this is just to piss me off, just to cost me money. Small claims wouldn't cost money, but you get my point. The court's going to say, no, that's immaterial. That is not relevant. The only relevant thing is, does he have a valid cause of action? Has he properly pled his valid cause of action? And can he prove his valid cause of action? That's all the court cares about. Literally all the court cares about. You're welcome, Ralphie. I hope you learned something today. Doesn't it work out better, Ralphie? Doesn't it work out better when you actually ask questions instead of coming in here and making stupid assertions? I think it works out better. You got a good answer to your question, right? So we're going to make what, women bar fight? If a woman has a valid claim against a man for breach of contract or assault or battery, she's got to get in a bar fight with him? What about people like paraplegics or quadriplegics? Do they just have no rights? Can everybody just trample over them because they can't bar fight? I don't think you've thought this out, Tim. I don't think you've thought this out. Well, maybe they're equal to you in bar fights, but I don't think there's a lot of women out there. No offense to women, but I don't think there's a lot of women out there who are going to beat me in a bar fight. There are some, but I don't think there's many. Anyway, so back to this. So Chili says it was due the 15th. I believe it was due the 16th. He filed this late due to a failure to substantially meet and confer that was not the fault of plaintiff, qualifying for a 30-day extension under a Code of Civil Procedure 430.21 subsection A2. Now, again, I think there's a problem with that particular subsection. Let's look at it. 4031A2. Or 430.21.A2. 430. Dot 21. In the Code of Civil Procedure, 430, and there is no 21. Maybe you meant 430.41. See, again, he failed to file and serve before the date the demurrer would be due a declaration saying under penalty of perjury that a good faith attempt to meet and confer was made. So I personally think that this is jurisdictional. However, the court did not find it to be jurisdictional. So last time we went through this, the court said that it's fine. Chile did the same thing, made the same pleadings, and the court went ahead. The annoying second monitor double boxes overlay. The annoying second monitor double boxes overlay. I don't know if anybody else is seeing it. I'm sorry if you're seeing it. Anyway, what were we saying? We were talking about this particular one. And do not, sir, do not tell me how to act. You're not my mom. You're not my dad. And why don't you think about what you did and control yourself before you worry about trying to control me, sir and or madam? So the court, I thought it was jurisdictional. The court apparently let Chile slide with it last time. So there you go. Additionally, Pierattini's counsel never served plaintiff with a second answer that was filed January 2nd, 2024. That particular, there's a proof of service under penalty of perjury where he says he served by email the documents. Now, whether or not that is appropriate, I don't know. Going back to CCP 1010, 1010.6, if there are local rules that are adopted that allow him to do it, or if it's an attorney, so if the trial court provides electronic filing and service, that's something, if it's part and parcel with it. But generally speaking, attorneys can do it, but I'm not entirely sure. Maybe Chile consented to electronic service. But it's the attorney one. This is the one that that I use to make other attorneys accept it because it's mandatory. They shall accept it. So all I have to do is confirm their email address, and bada boom, I can serve by email. I don't know why people like to. I think I do know why people like to serve by mail. It's because they can sign that they placed it in. They can sign that they placed it for collection in the normal course of business, and it normally goes out the same business day, and so they get like an extra day. of you not having the document to respond to it. But I just like nope. Chile has an affirmative duty. If his address changes, then he has an affirmative duty to update the court and opposing counsel. So near. I don't know if such a thing exists. Anyway, back to this. So he demurs under CCP 430.20a because the answer contains no new matter constituting an affirmative defense and includes a prayer for affirmative relief. Basically, the affirmative defense has to have facts. You have to plead facts for affirmative defense. Certified mail doesn't necessarily mean return receipt request. Certified mail is just certified mail. So they don't have to sign for it. It's just certified mail. Unless the statute specifically asks for return receipt requested. Essentially, Pierattini has refiled the same answer that this court previously found did not meet pleading standards. That is correct. Pierattini filed an answer with, quote, affirmative defenses, end quote, but without sufficient facts to put plaintiff on notice to any affirmative defenses. Plaintiff filed a MR, which was sustained by this court. Pierattini amended the answer by adding random jabs at plaintiff's character and legal conclusions. As a result, Pierattini's amended answer also fails to give notice to plaintiff and was filed for no reason other than to harass plaintiff. Well, does it really? Plaintiff prays it. The plaintiff's demur be sustained with leave for defendant to amend. Reason for untimeliness, yada, yada. And then the general demur to the answer should be sustained because the answer contains no new matter constituting an affirmative defense. Objection by demur. Affirmative defenses must be pled with facts. Affirmative relief. Now, he doesn't actually say like what's wrong with each one. He should set them out. Here's the affirmative defense. These aren't facts. He should plead facts. The declaration. And the various attempts to meet and confer. I went back over the answer, and I believe I have factually pled what I need to, other than things that are not new matters. In particular, I do not see how the affirmative defenses are new matters. A general denial is effective to controvert all material allegations of an unverified complaint. Generally, a defendant bears the burden of proving a new matter, and as such, the underlying facts must be specifically pled in the answer. Yes, that is correct. The phrase new matter refers to something relied on by a defendant which is not put at issue by the plaintiff. Yes. The basic consideration is whether the matters of the defense are responsive to the essential allegations of the complaint, i.e. whether they are contradicting elements of the plaintiff's cause of action, or whether they tender a new issue, in which case the burden of proof is upon the defendant as to the allegation constituting the matter. Yeah, so if what this is saying is I thought you were leaving, Ralphie. Are you lying? Are you a little lying sack of shit? I thought you were leaving, buddy. I thought you were leaving. Didn't you say goodbye? Shouldn't you get the fuck out? But basically, if the allegation made by the plaintiff is defendant did X, and then the affirmative defense is so if the allegation by plaintiff is defendant did X, and the affirmative defense is defendant did not do X, that's not pleading a new matter. But if the allegation is you're taking a dump, well, I guess good for you. If the allegation is that let's go to the defamation. If the allegation is that Pierattini said X, which was defamatory, and Pierattini says that X was true, you have to actually state like why it's true. You can't just say affirmative defense, it's true, because the truth or falsity of it is a defense to it. You have to prove it's true. The it's on you to prove it's true. So you have to like state why it's true. Things like that. A defense which negates an essential allegation of the complaint does not constitute a new matter and therefore need not be specifically pled by the defendant. Yeah. So again, like, failing to plead punitive damages, right? That negates a element. Each of the defenses negate an essential element of plaintiff's claims and are therefore not a new matter that require effectively. Saying the First Amendment protects this particular speech is not just negating an element of it, because in defamation you have to plead that they made a claim, they made a statement. Libel would be written, slander would be verbal. So just defamation. They made a statement that caused you harm, and here's how much it harmed you. And then they could go in and say, well, it was true, or it was an opinion, etc. So Mr. Katrinak, he's in a bit of a precarious position because Chile is correct. The judge has already ruled that that he needs to plead as facts averred carefully with as much details of facts which constitute the cause of action are alleged in the complaint. So that's what the judge already said on all of those. So I don't know why Chile's attorney, or not Chile's attorney, but Mr. Katrinak, Pierattini's attorney, doesn't think that he needs to plead more. I mean, the judge has already thought he needed to plead more. So anyway, there you go. That's on that. All right, moving on. We are in Las Vegas. And what happens in Vegas stays in Vegas unless it's filed in Pacer, right? So Michael Mee is now the attorney for Decastro, and he has filed his response. Why are we talking politics? Trump is a piece of shit. Biden's a piece of shit. All politicians are pieces of shit. They all deserve the rope. So they're opposing Las Vegas Municipal Police Department. They're opposing their motion to dismiss 12B6 and motion for summary judgment. So procedural history, don't really care about. Factual background. Yeah. Blah, blah, blah. Legal argument. 12B6. Liberal pleading. Yeah. Public record or uncontested video evidence and authenticity. Defendants in this action ask the court to look to matters of public record or to documents which the complaint necessarily relies if their authenticity is not contested. The defendants assert the body-worn camera submitted by defendants, in addition to Decastro's alleged YouTube videos about the event, constitute such evidence. In support of the authenticity of the body camera video submitted by defendants, the defendants have submitted Exhibit G, declarations of defendant officers. Plaintiff observes for the record that Officer Torrey's declaration is signed and dated. Officer Bork's declaration is signed but not dated. Officer Dingle's declaration is signed but not dated. Officer Doolitle's declaration is neither signed nor dated. Officer Sandoval's declaration is neither signed nor dated. Officer Sorensen's declaration is neither signed nor dated. Interesting. For these reasons, there is insufficient evidence in the record to support the authenticity of much of this video evidence based on the lack of these declarations being signed. In addition, plaintiff, prior to engaging in full discovery, has no way of knowing whether any videos produced by the defendant officers or LVMPD are full copies or excerpted copies of the original videos. Well, disclosures have already been done, and there has been responses to discovery. So I'm not entirely sure that the statement is, well, I mean, full discovery. Decastro, Decastro did interrogatories, requests for production, etc. Disclosures were done. So I don't know what, like, this is a weak argument. This is a weak argument. Plaintiff is not able to concede the full authenticity of such videos, that they are not clipped or excerpted at minimum from original files, and that they do not omit relevant evidence without a full opportunity to engage in discovery. There's been discovery. Plaintiff can acknowledge the subject videos at least partially depict the evidence or the events described in the complaint, but as plaintiff is not involved in obtaining, storing, clipping, or not clipping, excerpting, or not excerpting these videos, plaintiff cannot concede these videos are full and complete copies of the videos recorded by the subject defendants on the date of the incident, and objects on that basis to their consideration within the Rule 12b6 framework prior to the full discovery being completed. However, they acknowledge that there at least 3 of them are signed. So Tory, Bork, and Dingle. And Bork was the one there for the entire time. Again, this is bad lawyering, not by me, attorney me, right? His name is me. Not by attorney me, but by the other attorney who should have gotten signed declarations from all of the officers and made sure they were all dated. But Bork was there the entire time, so I'm not sure what they're going to get from Doolittle or Sandoval or Sorensen. And if Doolittle, Sandoval, and Sorensen's videos all corroborate Tory, Bork, and Dingle, then unlike the body-worn camera video evidence, YouTube videos subsequently produced by the plaintiff are not inherently video evidence, quote, on which the complaint necessarily relies. Necessarily? These videos are created after the fact and commingle commentary with prior recordings of the events in question, among other matters. While the defendants might argue that such evidence has impeachment value, such impeachment would be relevant for trial, not a Rule 12b6 motion to see whether or not claims have properly been set forth. Well, here's the thing, though: statements by by your opponent, statements by Chili, even though they're made after the fact, don't change the fact that the defense can rely on them. Like, for example, if there was a deposition, and at deposition, Chili said something that contradicts something in the complaint, the defense can rely on it, even though it's said after the fact. I don't understand this particular argument because it's not just impeachment value. They don't have to rely on statements that Chili made for impeachment value. They can rely on these statements for, the actual statements that the attorney made. Or not the attorney, that Chili made. As such, the complaint does not and cannot logically, quote, rely upon such after the fact videos created by the plaintiff if they do not fall squarely within this uncontested evidence framework which the defendants seek to invoke. Well, I don't know how Chili is going to say. Chili's position here is essentially that the statements and videos that I put out on YouTube, I am actually contesting the truth of them. Chili, am contesting the truth and accuracy and authenticity of my own videos that I put out and my own statements in those videos. So this evidence is not properly before the court for consideration under 12b-6, and consideration must be deferred until after discovery has been completed. Well, you're slicing the turd kind of thin here. The court might give Chili's attorney another bite at the apple to conduct more discovery. Chili's attorney is still going to be hamstrung by the fact that Chili has already asked a shit ton of stupid fucking questions. And the limitations on the number of interrogatories and things are going to bind Chili's new attorney. You can't just uh, cycle through new attorneys to get to ask new discovery questions. So, motion for summary judgment is premature and would deny plaintiff a reasonable opportunity to engage in discovery. He's already had again. Chili filed a motion based on discovery having been answered, and Chili thought it wasn't answered completely, and the judge denied that motion. So discovery has been engaged in. I just don't know. This is like I can see the court giving me another opportunity to do more discovery, like depositions and things like that. But it's rough. Although Rule 56 allows a motion for summary judgment to be filed at any time, Rule 56 also allows the court to issue an order, as is just, denying the motion or ordering continuance for opposing party to pursue discovery. Generally, the party is entitled to an opportunity to pursue discovery before responding to a summary judgment motion. Again, there was discovery. So, therefore, the court should find that converting the present motion into a motion for summary judgment is premature pursuant to Rule 56D of the FRCP. But see, here's the quote. Here's the fucking problem. Motions for summary judgment. This is from Smith versus Jones. This is cited literally by Chili's attorney. Motions for summary judgment can be filed at any time, but are often denied as premature when submitted before the parties have had time to conduct at least some discovery. At least some discovery. That's the quote. And from that, me is trying to say, therefore, the motion for summary judgment should be denied to allow both parties to complete discovery. There's a difference between some discovery and complete discovery. The court that they're citing says you have to have some discovery. Very weak argument. Again, like I could see the court saying, well, Chili was fucking stupid prior. So I'm gonna give a real attorney an opportunity to try to fix some of the bullshit that Chili was doing. I could see a court doing that. But I don't think that it's a good motion. This would be a pity motion. This would be where the court wants to give Chili another shot. Not only would summary judgment on any of the causes of action be premature with respect to case law governing litigants' right to engage in discovery regarding properly stated claims for relief. Such request here is contrary to the parties' stipulated discovery plan in this action. The parties have set the following deadline: March 15th, expert disclosures; April 15th, amend the pleadings; May 15th, discovery cutoff; June 15th, dispositive motions. The parties further agreed to limit to no more than 10 depositions by the plaintiff and no more than 10 depositions by defendant. Well, again, they've conducted some discovery. I'm going to call bullshit, Laura. I think you probably are flicking the bean right now, thinking about GMK and Ralphie mutually masturbating. And as long as they don't make eye contact, it's not gay. While such a discovery motion may not be tantamount to barring summary judgment, yeah, it may not be, huh? It may not. Prior to a fair opportunity to engage in those scheduled instances of discovery, the court should regard granting summary judgment in such cases as being extremely premature, especially where plaintiff has properly stated claims for relief and where summary judgment is sought well before any of the above discovery deadlines has elapsed. Well, what about the deadline that they set for disclosures, for normal disclosures? Are we doing sexy stuff? Oh, it's not gay as long as they don't break eye contact? Well, there you go. Important distinctions. Today I learned that it's not gay as long as they don't break eye contact. Okay. Finally, even if this court were to rely upon the fact, undersigned counsel notes for a record that counsel for the defendants has responded with great courtesy and granted extensions were requested due to undersigned counsel's late entry into this case, including filing an opposition to the president through February 2, 2024. But nevertheless, there is no avoiding the difficulties such late arrival presents for attempting to address the earlier request for summary judgment where discovery is ongoing. But is it ongoing? Do you have, Mr. Me, do you currently have interrogatories out? Do you currently have a deposition scheduled? Is discovery ongoing? But Jeff, did you lose it or did you win? You know what I'm saying? You know what I'm saying. Even if this court relied upon the fact that the plaintiff has been able to engage in, quote, some discovery, end quote, prior to receiving the motion for summary judgment, it must be noted that plaintiff was representing himself per se until January 10th. Undersigned counsel has been in this case less than a month at the time of this filing and is still in the process of fully reviewing the 75 filings which were made by the parties in this matter prior to the undersigned's notice of appearance. Undersigned counsel is still reviewing what additional discovery requests from plaintiff to the defense would be warranted at the present time, and discovery has not been closed. For this additional reason, it would be premature to deny plaintiff a full opportunity to litigate these claims via additional discovery requests, which, as set forth in the second amended complaint, have been properly pleaded. Absolutely not. Absolutely not. Can they? Yes. But will that result, generally speaking, in a motion to compel? Yes, it probably will. Will the court require them to answer? Maybe. It would depend on why they decided not to answer. D. Plaintiff has pled valid claims under Rule 12b-6. A claim of excessive force during an arrest is analyzed under the Fourth Amendment subjective reasonableness standard, right? Didn't the court grant leave to No, the court denied everything with the excessive force, right? I think the court denied everything with excessive force. So there's like a battery claim that battery and excessive force, I think the court denied the 12b-6 on, or they didn't, or excuse me, I don't think they actually pled a motion to dismiss for the first time, the first motion to dismiss to the first amended complaint. I don't think they asked for a 12b-6 on the excessive force. So I think that the excessive force cause of action and the battery action, I think they're relying on summary judgment. Well, I mean, as long as he doesn't break eye contact, right? Isn't that? So the excessive force, I think, they're going to rely on the videos, and if the videos, if the body cam videos are part of the uh, if the body cam videos are part of the complaint, if the court determines that they're pled into the complaint by reference from Chile, then it's a 12b6. If the court finds that they aren't pled into the complaint, uh, then they're asking the court to make a determination based on summary judgment standards. Well, hitting the balls, like let's just look at this. Let's just look at this a little bit more. Let's steelman Chile's argument. If they're patting him down, if they thought they were patting him in the balls to see if there was a weapon tucked neatly under his nutsack, they might have thought that they were patting him in the balls. Chile might have interpreted the same action and the same amount of force of them patting him in the balls as them hitting him in the balls. Because as every person who's ever had balls knows, that sometimes the lightest boop to your nuts can make it feel like your stomach is falling out of your ass. So, you know, what they might have thought was a pat to the balls, Chile might have thought was them hitting him in the balls. And so from a different perspective, you know what I'm saying? So the question at that point would be, if it was a reasonable amount of force for them to pat him in the balls, even if it caused him to double over and feel like his guts were falling out his ass. So that's you know, different perspective. That's why like Ralphie's initial position and who's that other dumbasses that, God, I forget his name. I want to say Stephen Hawking, but that's a whatever. Their positions like this completely lacks merit. I mean, there's two sides to every story. You know, there's your side, there's my side, and then there's the truth. And who knows? And that is what happens when you say things like "don't be a cunt merb." You get a timeout, not a ban, a timeout. Because I don't really appreciate people coming into my stream when I'm explaining things and telling me I'm a cunt. Oh, wow. Did they really? Nice. I love them donations. Donate harder. Determining whether force used to effect a particular seizure is reasonable under the Fourth Amendment requires a careful balancing of the nature and quality of the intrusion and the individual's Fourth Amendment rights. Yada yada. Ninth Circuit repeatedly. So I don't even know if the videos would be sufficient to prove whether or not there was excessive force. Can a video show how much pressure is being exerted on the wrists with the cuffs and how tight the cuffs are? Can a video show that? Like, I mean, maybe when you take the video off, if you see the cuff marks or something like that, would a video show that? I don't know. I don't know that it would. Would a video show excessive force being applied to an ulnar nerve? I don't know exactly if that is or isn't, if you can or cannot do excessive force by applying pressure to the ulnar nerve. I haven't looked it up. Don't really care. But the question is, can it be excessive force to apply that pressure? Can it be excessive force? Like, would a video conclusively show that an officer tapped his nuts? I mean, do the video show the officer's checking his ball area for in a frisk, or do none of the cameras show it? And if the cameras do show it, do they show it sufficiently to show how much pressure was applied, how much striking force was applied to the nuts? So, I mean, it may be able to prove the negative. If the videos show the entire time his arm and where the cop's fingers were the entire time, maybe. But if the camera goes away for a minute, then all of a sudden there's a question again. So I don't know if the videos are gonna actually be sufficient to allow the summary judgment, because some of his claims of, if I remember correctly, the pressure to the ulnar nerve, the didn't he claim the handcuffs were too tight, torture cuffs were too tight, and the punch in the balls, right? I think there were 3. I could be wrong. So if so, then there you go. Plaintiff's second amended complaint sets forth the following relevant facts. Officer Bork was visibly upset when he came after plaintiff. Well, I don't know is that a fact? Visibly upset? Is that a fact that he was visibly upset? I mean, maybe that would be Chili's interpretation of it. Like, Officer Bork had a frown on his face when he came after plaintiff. Officer Bork had a scowl on his face when he came after plaintiff. Officer Bork was shaking when he came after plaintiff. Those are more facts. Visibly upset, is that a fact? I don't know. That's kind of questionable. Bork walked aggressively towards plaintiff as if to use force. Well, is that a fact? I don't think that's a fact. He walked towards plaintiff, and plaintiff interpreted that as aggressive. He got close to plaintiff. Is that a fact? Bork manhandled plaintiff. What does manhandled mean? Punched, kicked. We know what those are. What does manhandled mean? Bork manhandled plaintiff and said, "I'm going to put my hands on you." So the statement, that's a fact. He stated, "I'm going to put my hands on you." That's a fact. He's alleged a fact. But Bork manhandled plaintiff, is that a fact? I don't know if that's a fact. Well, that's something that an expert would have to testify to. Bork put his hands on plaintiff unnecessarily. Is that a fact? I don't think so. Bork put his hands on plaintiff. Is that a fact? Yes. Unnecessarily. Is that a fact? No. Officers forcefully grabbed plaintiff even though he was cooperating fully. Forcefully grabbed plaintiff, that would be a fact. Plaintiff was cooperating fully. I guess that would be a fact too. Plaintiff made the officers aware that he suffered from a prior shoulder injury. That would be a fact. If he made them aware, if he says, "I made them aware," then that would be a fact. Officer Sandoval yanked and squeezed forcefully on plaintiff's arm despite his shoulder injury when such was unnecessary. Well, yanked and squeezed forcefully on plaintiff's arm, fact. Despite his shoulder injury, fact. When such was unnecessary. That's a conclusion, I think. Plaintiff was not a threat. That's a conclusion. Was cooperating. A conclusion or a fact. I'd say that's a fact. And was surrounded by 4 different police officers. Fact. Sandoval ordered plaintiff to look straight ahead. That's a fact. For no legal reason. That's a conclusion. And Sandoval squeezed plaintiff's elbow. That's a fact. Applying nerve pressure on the ulnar nerve. That's a fact. Merely for plaintiff not immediately looking straight ahead. I guess that's a fact. So Sandoval intentionally and deliberately pressured the ulnar nerve to cause pain and permanent damage. That's a fact. Sandoval stated it was officer policy to use pain compliance on ulnar nerves for random commands, including not looking straight ahead. That would be a fact. If he actually said that, that would be a fact. These actions caused plaintiff severe pain and paresthesia from compression of his ulnar nerve by officers. That's a fact. Plaintiff pleaded for help in response to his physical pain, which was ignored by the officers. That's a fact. Defendant squeezed plaintiff's nerve for more than 15 total minutes. Fact. Sandoval spread plaintiff's name uncomfortably wide. Legs? Sandoval spread plaintiff's legs uncomfortably wide? Ass cheeks uncomfortably wide? I hope Merb is being sarcastic. None of that is facts. These are allegations that are factual allegations that may or may not be true. I'm not being sarcastic. The difference that I am trying to alert you to, sir and or madam, is that you have to make factual allegations. You have to allege facts in your pleading, in your complaint. That's why a 12b6 is a failure to allege facts sufficient to support your claim. So no, I'm not being sarcastic. You are just ignorant of what we're talking about. I hope you are less ignorant now. You know how. So, oh, you're about due to go for your bar exam. You know how many people you know how many people got on me when I said that a fact isn't necessarily true? Like the definition of fact means it's true. Well, how the fuck can you plead a fact if it is necessarily true, and then have someone plead a fact that makes your allegation untrue? How is that a fact? How is that a fact? But yes, facts are not necessarily true, because technically what we're talking about is you're alleging something that, if true, would be a fact. Technically, that's what's going on. Your allegation, if true, has to be a fact in order for your pleading to be correct. They kind of a shorthand. It's fact-based pleading. You have to plead facts. This is a correct statement. Facts in the way it's being used is not necessarily true or false, but it's a statement that, if true, would be a fact and not a conclusion. We're differentiating between facts and conclusions. So Sandoval spread plaintiff's ass cheeks uncomfortably wide and purposefully and maliciously and with significant force struck plaintiff in the testicles with what felt like a closed fist. Those would be facts. Defendants also forcefully moved plaintiff into a police vehicle and pulled the seatbelt as tight as they could, knocking the air out of plaintiff. Again, those would be facts. This guy is a motherfucking idiot. I have been baffled. He does these little, he tags me in these dumbass little videos that he does where he debunks me. Fucking hilarious. Go to his channel and watch them. They're fucking hilarious. The guy is like the king of Dunning-Kruger. When vexatious litigation is illegal, and Chile admits in a video that his motivation for suing makes him a vexatious litigant, taking Chile's side on that makes you guilty of sucking that Chile dick. Well, vexatious litigation is not illegal. So, strike one. Chile did not admit in a video that his motivation for suing made him a vexatious litigant. That's strike two. And no one is taking Chile's side on this, so no one is guilty of sucking that Chile dick. That's strike three. You're out. Defendants caused plaintiff to sustain physical injuries physical pain, mental suffering, emotional distress, and other damages. That's a conclusion from the above things. Plaintiff did not do anything which would put any officer in reasonable fear for his or her safety. I don't know why they think that is a requirement. You have well, I'm not a flat earther, nor am I a frauditor, and he, in quotes, debunks me. So I don't know why. So again, I don't know why Chile thinks that the officer has to be in reasonable fear of his safety to arrest someone and to search that person incident to a lawful arrest. And once you are under arrest, why the officer needs to be in reasonable fear of his safety to place you in a seatbelt. Do you? That Bork and Sandoval engaged in excessive force against the plaintiff after he was already in custody, causing physical and mental damages. That is not a complete sentence. And that is also conclusory, not a fact. Here, turning to the relevant factors, it is clearly, fucking clear. It's clear. The plaintiff has properly pled his excessive force claims. One, the severity of the crime at issue. Did he plead the severity of the crime at issue? And a lot of the things had to do with resisting arrest. How much force can an officer use to overcome someone's resistance if they are resisting arrest? Huh? How much can they use? Whether plaintiff posed an immediate threat to the safety of the officers or others, he was resisting arrest. They can use sufficient force, but not too much, to effectuate the arrest. Whether plaintiff actively resisted arrest, he did. He actively resisted arrest, at least from what I saw in the videos. While these factors act as guidelines, there are no per se rules in the Fourth Amendment excessive force context. Here, plaintiff has sufficiently pled the severity of the crime at issue was minor. Resisting arrest is minor? Is resisting arrest a minor? Is obstruction and resisting a minor? Well, it's only a misdemeanor, right? But you still, the cops still get to, if you turn your level of resistance up to an 8, the officers get to turn their level of force up to 9 because they get to exert more force to overcome your resistance. Probably true with passive resistance. Sure, passive resistance is different, absolutely, but he actively resisted. Like, we saw him actively resisting. And even with passive resistance, the officers can, if your knob is at a 0 resisting, they can turn it to a 1 to effectuate the arrest. So if they tell you to stand up and you don't because you're sitting down passively resisting, well, then they can get you for resisting because you're not complying. Here, plaintiff has pled the severity of the crime at issue is minor. Defendants cannot reasonably contest this. I don't think they have to. Plaintiff has pled he was arrested as being targeted as a member of the press and for filming police activity. How does that go? How does that go towards resisting arrest or the excessive force? I don't understand. I don't understand why that's pled here. That doesn't seem relevant. Defendants had no reason to believe Chile was dangerous other than the fact he inserted himself into an existing stop, other than the fact that he refused to comply with orders, other than the fact that he literally jerked his hand away from the cop, resisting arrest, actively resisting arrest, and refused to comply, forcing the officer to exert more and more force to restrain him and detain him and then arrest him. He was merely filming a traffic stop. That's all he did. Well, if that's all he did, then that is crazy. I mean, if that was all he did, he wasn't arrested for filming a traffic stop, though. He was arrested for obstruction and resisting, right? So that's kind of crazy. Second, at the time the allegations of excessive force occurred, defendant was already detained, physically restrained, and cooperating. Well, those pesky videos might not show that. Defendants do not seriously contest these facts. Well, what is it? You see that qualifier there? They don't seriously contest it, meaning they contest it. He just is trying to minimize that they're contesting it. Or present any evidence to support a reasonable belief the defendant, surrounded by 4 officers in handcuff, presented a safety risk. Again, this is a misdirection. He didn't have to be a safety risk. He had to be not complying. He had to be resisting arrest. One thing you'll learn, Adam, is that you don't get to pick your cases. And I'm going to assume, do I want to assume that this guy is taking it on contingency or not? I don't know. He might take it on contingency, or he might be getting hourly. If he took this on contingency, then I would fault him a lot more for it, because he got to look at it and absorb it, and he should know that while there is some value in it, he's probably going to spend way more hours. His actual return per hour is going to be pretty low. But if he's doing it hourly, well, everybody's entitled. Yeah, he's entitled to the best shot he's got, and you take what you're dealt. The excessive force claims aren't completely frivolous. That's all I'm saying. They're not completely frivolous. You can make an argument. Defendants now claim that they were required to squeeze plaintiff's ulnar nerve as pled in the complaint, despite the fact he was cooperating, surrounded by officers and handcuffed, because they needed to maintain control of Decastro so he did not fall and injure himself. This is objectively reasonable. Notice how this part's in quotes. Did they say they were required to squeeze plaintiff's ulnar nerve? I don't know about that. If they did, I'll bet it would be in quotes. Let's look at defendant's motion at 12. Let's look at that. Motion to dismiss. They said it was at 12? What did you say it was at? Motion at 12. I'm just guessing. Page 12, maybe? I don't know. Maybe there's a paragraph number 12. However, the footage clearly demonstrates that Officer Sandoval was holding Decastro's arm in a reasonable manner, not applying any significant force to the arm. Where does he? So what I'm wondering is, where was this quote needed to maintain control of Decastro? Well, let's do this. Control F. So line 26 and 27 of page 12. It'd really be helpful if instead of just saying at 12. Similarly to Castro's claim that Officer Sandoval excessively squeezed his arm is refuted by the video evidence. The videos clearly show that Officer Sandoval maintained a grip onto Castro's arm due to the fact that he continued to move, twist, and slightly resist after handcuffing, as explained to DeCastro by Sandoval. Because DeCastro was handcuffed and lacked use of his hands, Sandoval needed to maintain control of DeCastro so he did not fall and injure himself. This is objectively reasonable. So they turned that into defense now claimed that they were required to squeeze plaintiff's ulnar nerve. As pled in the complaint, you're in Scotland now. You're moving all over the world, sir. You're a man of mystery. No one knows what country you're going to pop up in next. This explanation is incredible. The defense offered no authority for the notion that officers must squeeze a suspect's ulnar nerve, causing physical pain and damage for 15 minutes in order to prevent them from falling down. Well, gosh, if that's what they had claimed, that would be something silly. There's no evidence in the record that there's any special circumstances making DeCastro likely to fall down at any point in this physical restraint. Well, let's see what they said again. Let's look again at what they said. He continued to move, twist, and slightly resist after handcuffing. And they didn't want him to fall down because if he fell face first, let's just imagine. So once you are in custody, you know how officers have no duty to protect? Once you're in custody, officers have a duty to protect you. Officers, as soon as you're in custody, the state has a duty to protect you. And so if Chili fell face first with his hands handcuffed behind his back, he could sue the state for failing to protect him. That might not make sense to Chili, but that would certainly make sense to a court. There's no evidence in the record that there's any special circumstances making DeCastro more likely to fall down at any point during this physical restraint. Next, the officers argued the claim that defendant struck plaintiff in the groin is belied by the video evidence. Again, this is not the standard. The standard is whether the claim has been properly pled. There's no question the allegation about striking plaintiff in the groin unnecessarily and for no lawful enforcement purpose was validly pled. However, it's not just if it's validly pled. It has to be... there's a term for it. It's not just whether it's validly pled. It has to be credibly pled. And I'm probably saying that wrong, but it has to be believable. And if there is the video evidence, and if the video evidence is deemed to be part of the complaint, incorporated by reference into the complaint, then the court can consider it. And plausible. Thank you, Alpha Fox Adam. It has to be plausible, not credible, plausible. So if the court looks at the video evidence and they see no evidence of him being struck, then it's no longer plausibly pled. However, even if the court is inclined to consider the video evidence is not dispositive. The defendant's claim the video confirms this did not happen is completely overstated. The video is not clear or detailed enough to show the degree of force, the force of the impact, or the manner in which the contact was made in which the officer struck the defendant in the groin. Whether this was a normal pat down or a retaliatory strike for the plaintiff exercising rights and or being perceived as annoying to the officer is a matter for the jury. It may well be. It may well be. It cannot be definitively determined by video. Well, the judge might disagree. Mr. Caruso. Mr. Caruso. Mr. Caruso. Mr. Caruso. Guess what I'm looking for? Did I not save it? Damn it. What if it was on the documents? No. No. Videos. No. Damn it. Did I not save it? Did I really not save it? Oh, that made me so upset if I didn't. Bum, bum, ba da 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 ba da 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 da. Hmm. Well, it makes me super sad. That makes me super sad. Poop sticks. I found it. I found it. My favorite, Mr. Caruso. Mr. Caruso. Present the video file. Video file. Download. Uh-huh. 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 Why doesn't it appear here? But I found it. Found it. Yeah. Yeah.
Mr. Caruso. Mr. Caruso is well, he's not like the kids over at the Welsh News Network. He's not a
I told you. No. No. I told you I wanted to vacuum and dust this room. No. Get out.
hang on one second. Mr. Caruso. Mr. Caruso is well, he's not like the kids over at the Welsh News Network. He's not a
I told you. No. No. I told you I wanted to vacuum and dust this room. No. Get out.
hang on one second.
Oh my god, I love that fucking clip. Oh my god, I love that clip. Every time I see Anthony Caruso, I always think, Mr. Caruso, Mr. Caruso. Oh my God, I fucking love that. Oh, Jesus Christ. Oh, that was the best. Intentional or otherwise, and I seriously expect that was not intentional. As much as he tried to play up that was staged, that was the best fucking thing ever. Oh, the defendants claim that this was a routine pat down. Plaintiff claims a retaliatory strike. The video confirms that some contact was made to plaintiff's groin. It is not a situation where video shows that nothing similar to the allegation occurred. This is a video that shows forcible contact did occur, but it leaves open to the finder of fact, the exact meaning, degree, or legal significance of that forcible contact. And I think it's a valid argument that he's making. But I think that a court can look at it and say, well, the effect on Decastro is clear. If he doesn't actually flinch or double over or show any response to it, then we can make assumptions. We can make valid assumptions as to how much force was actually applied. So it's a valid argument that me is making, but it's not necessarily dispositive. So, accepting these allegations is true. Plaintiff did not pose a threat at the time of these acts of physical violence were engaged as pled. Accepting these allegations as true. Plaintiff did not pose a threat at the time these acts of physical violence were engaged in as pled in the complaint. These allegations say a plausible claim for relief for excessive force in violation of plaintiff's Fourth Amendment rights. Well, again, if he's resisting arrest, then they can use sufficient force to overcome that resistance. The fifth, sixth, and eighth causes of action. So the fifth is First Amendment the fifth is chilling the First Amendment. The sixth is First Amendment retaliation. And the eighth is selective enforcement. Now, the chilling the First Amendment and First Amendment retaliation, I think, are intertwined. I think the court gave him leave. It was dismissed without prejudice. The court gave him leave to replead those appropriately. And selective enforcement, I think, is also kind of tied into the First Amendment retaliation. Will you have time to go through a thing? I don't know. I don't know what the thing is. If it's your sphincter, probably not, because you only do almost anal. Wildly interesting. Is almost anal wildly interesting, or is it mildly interesting? So I can't answer your question. So discriminatory enforcement of a speech restriction amounting to viewpoint discrimination is a violation of the First Amendment, even where the statute would otherwise be a permissible restriction of speech if equally applied. So what speech was he engaged in? You know what? Those are words to live by. That is excellent advice. And so, but it's almost anal, wildly interesting. Almost anal. So what was he saying? What viewpoint was he expressing? If they were, let's just say that they did in fact arrest him for filming. What viewpoint was that? What viewpoint was it? I don't think there was a viewpoint there. I don't think there was a viewpoint. that was being expressed. Filming is a content neutral kind of activity. I mean, maybe you can edit the film to show what you want it to show, but I'm not entirely sure that you could really argue that filming, that restrictions against filming are viewpoint discrimination. In other words, a selective enforcement claim based on viewpoint description can be brought under the First and 14th Amendments. Awesome. So what he's going to have to show is that other similarly situated people were allowed to film. And similarly situated is going to involve them inserting themselves into a traffic stop. So he would need to show that there is something like that out there where some people are allowed to film up close and insert themselves into traffic stop if they're pro-police, and others are not allowed to do that if they're anti-police. The fundamental principle behind content analysis is the government may not grant the use of a forum to people whose views it finds acceptable, but deny use to those wishing to express less favored or more controversial views. The fundamental principle behind content analysis might not. May 9. What were we? We're looking for April 27, 2015. April 27, 2015. August 2020. Oh, that's not the right hearing date. Oh, hold on a second. Nope. None of those are the right dates. March 2016. July 2016. And again, we're looking for April 2015. April 2015. August 22. What if Pacer? We're going to Pacer. And then this is going to be Nevada. Nevada District Courts. Log in. And then we're going to look for this copy. Document filing system. Let's go. Let's go. Query. Let's go. This is plain text. Find this case. Run query. Docket report. All right. So April 2015, March, April. April 27th. All right, we're looking for April 27th, 2015. April 27th, 2015. This one right here. All right. And then where are we looking at? We're looking at page 8. 3, 4, 5, 6, 7, 8. Well, that's the problem. They're going to have to. Chile had to, in his complaint, point to a control group against which Chile may contrast enforcement policies. He did not do so. All right, so back to this. Courts must be willing to entertain the possibility that content-neutral enactments are enforced in a content discriminatory manner. Why are we talking about content discriminatory? Wouldn't it be viewpoint? It doesn't make any sense to me. If they were not the First Amendment guarantees would risk becoming an empty formality, as a government could enact regulations on speech written in a content-neutral manner so as to withstand judicial scrutiny, but then to proceed to ignore the content of the regulation's content-neutral terms by adopting content discriminatory enforcement policy. It's viewpoint discrimination. This is a similar showing to what plaintiffs need when alleging their equal protection claim. Because plaintiffs have adequately alleged a selective enforcement claim under the Equal Protection Clause based on viewpoint discrimination. They also have adequately alleged their First Amendment claims. Further, the same reasons that qualified immunity cannot shield defendants from any equal protection claim based on selective enforcement, qualified immunity will not shield defendants against a selective enforcement claim brought under the First Amendment. But again, they failed. They failed in point to. Chile never pointed to a control group. He never showed anybody else who was able to insert themselves into police stops and disrupt things and get away with it because they were pro-cop or whatever the opposite of what he thinks he is. Retaliation and selective enforcement claims have been properly pled. I don't think so. Decastro's claim is only survive if he can present objective evidence that he was arrested when other similarly situated individuals not engaged in the same sort of protected speech had not been. Defense argued that Decastro provides no factual allegations suggesting other individuals who illegally interfered with traffic stops were not arrested. First of all, he denies he was illegally interfering with any traffic stop. Well, that's great. That's going to be a conclusion of law that the court will draw, just like it was a conclusion of law that the court drew that there was probable cause. At the outset, individuals have a First Amendment right to film matters of public interest, which includes law enforcement officers performing their duty. Right, but it's the illegally interfering with the traffic stop is the problem. Just because you're holding a camera doesn't mean you get to break the law. It's not him filming that was the problem. It was him inserting himself into the traffic stop. He walked in and started talking to the gal who'd been pulled over, Jane Doe, asking if she was okay, refusing to back away. Indeed, the First Circuit has held, this isn't the First Circuit. Nevada isn't First Circuit. Nevada's Ninth Circuit. Why are we talking about First Circuit? Why are we talking about First Circuit? And then 11th Circuit. Then Second Circuit. Oh, finally a Ninth Circuit. Project Veritas versus Schmidt is Ninth Circuit. Project Veritas got into the Ninth Circuit. It is a Ninth Circuit case. Interesting. Good times. Holding it, an article addressing art market fraud is certainly protected under the First Amendment. You know what? Inserting yourself into a police stop and authoring an article addressing art market fraud, basically identical. There's basically it's the same thing. Obviously, we're not stretching to try to apply publishing an article to interfering in a police stop. To the extent the defendants in this case issued orders to plaintiffs to move back or stop filming under the belief that Nevada's obstruction statute permits officers to issue such orders to protect the, quote, privacy, end quote, of third-party citizen with whom law enforcement is interacting, again, has no basis in the law, nor have the defendants cited any law to this effect. It is not obstruction of justice to passively refuse to obey unlawful orders issued by a state law enforcement officers which violate the First Amendment. I believe, if I remember correctly, that the officer told him to move away and not interfere with his stop, and justified some of it by saying that she has a right to privacy. I'm assuming that the officer was concerned that he would be getting her personal details, her information off of her driver's license, things like that. Things that Decastro himself recognizes are private, as he has them covered up. He doesn't actually post them on the internet. He has blacked out images of them. What do you mean I'm not a perv? Of course I'm a perv. Yeah, see? If Chris H said it, then I must be a perv. Second, Decastro has sufficiently pleaded facts supporting his claim, and those facts must be taken as true for the purpose of notice pleading. Specifically, plaintiff pleads in the second amended complaint that he's a member of the press. When directed to back up while filming a public event involving law enforcement, plaintiff stepped back. See, is it a public event? Is a traffic stop a public event? I don't know. Plaintiff informed defendants that he was recording as a member of the press. So the press don't have the press do not have any special right of access. That's number one. And second, even in Glick, which is the most on point case, the court said that Glick had a right to record, subject to reasonable time, place, and manner restrictions. Subject to reasonable time, place, and manner restrictions. Is it a reasonable time, place, or manner restriction to instruct Chile to back off, to back away, to move back? Well, how far the order to move back is would be what would make it a reasonable restriction, right? If you said back up 5 feet, is that reasonable? Probably. Back up 10 feet. Is it reasonable? Probably. 20 feet? Probably. 100 feet? Probably not. I mean, depending. If there's a bomb threat or something, maybe 100 feet is completely reasonable, right? Cite the law. Cite the law that says that. What if one news outlet does an undercover story on another news outlet? Would either one of those two news outlets lose their ability to call themselves press because one inserted themselves into a story by having an undercover reporter reporting, or lose their ability to call themselves press because another news outlet did a story on them? That's nonsense. It's nonsense. The people have freedom of the press. Freedom of the press is a right guaranteed to the people. The people are the press. There's the First Amendment guarantees your right to freedom of speech, freedom of press, freedom of association, freedom to petition the government for redress of grievance. What did I miss? There's 5, right? I missed one. Whatever. You get the point. Religion, speech, press, association, and petition. Yeah, there's 5. Officer Bork first claimed plaintiff had a lawful duty to move back and not film because driver was interacting with deserves privacy. Paragraph 43. I don't really care to go back and look at it. Let's just assume that he said that. This notation is contrary to clearly established law permitting the filming of persons in public and filming of law enforcement activities. Which law? Which law? Cite it. Contrary to what clearly established law? You mean the one in Glick where it says, yeah, I got it. I got it. You're behind, son. You're behind. So the clearly established law that they're trying to point out is the subject to reasonable time, place, and manner restrictions. There is no law, nor have defendants cited any law indicating that citizens cannot film law enforcement interactions involving private citizens or there's a right to privacy which supersedes the First Amendment in such situations. You can film public officials in the performance of their duties subject to reasonable time, place, and manner restrictions. So the question is whether it was a reasonable time, place, or manner restriction. Your knowledge of Chili's turds is questionable. Very questionable. Furthermore, plaintiff has pled similarly situated individuals at a similar distance were not treated yet, but he didn't plead them with specificity. The requirement was that he has to point to a control group. This group was treated differently. So the chalking people in this case, I remember this case, they were cited with after writing critical messages of defendants, but so they identified the children who ride on sidewalks within the metro jurisdiction. Here they go. So who see these guys, they identified children are able to mark on sidewalks and not get arrested with chalk to make their little hopscotch things, right? I would bet he watched the body cam videos. I would bet he watched the body cam videos. He may also have watched the chili videos. Because he's being very careful to argue the complaint. I would bet he did. I would bet he did watch them because he's being very careful not to reference them. Plaintiffs argue defense argue plaintiffs must compare the group to a narrower class and everyone who uses sidewalk chalk. Oop, I'm in the wrong spot. Hold on a second. Plaintiff's alleged Officer Bork engaged in profiling against members of the press by stating First Amendment auditors are known for dropping their phone, pulling out guns, and shooting at officers, which is a prejudicial claim that has no basis in reality. But again, you have to identify a group that is treated differently than you. And allegedly, Officer Bork thinks that members of the press are known for dropping their phone, pulling out guns, and shooting at officers. Yeah, he's literally representing Chili on the criminal defense, and so he would have seen all of these body cam videos as part of Chili's defense. He brought them up. He specifically brought them up, but he's not arguing them. He's not saying that it shows at this time. The one mention he did is saying that the body camera footage does show contact being made, but it doesn't show how the contact is being made. But he's being very careful to walk around it. But this is an excellent point that, yeah, he is the defense attorney. He has watched the videos because it's relevant to the defense. Yeah. Mea culpa. There you go, Bill. In other words, Bork operated under a presumption that citizens that film law enforcement presented a higher danger, which is a belief that does nothing other than purport to give law enforcement a right to treat any exercise of the First Amendment as indicative of danger. So here's a real fucking problem with this. Chili saying, I am a member of the press and I was filming police and I was treated different because everyone who films the police is treated poorly. Absolutely, Anthony. Absolutely. I'll take a shot of bourbon in mine, just in honor of Coded. Not the cheap bourbon either. Top shelf, please. So literally me fucked this argument up real bad because me had to show that Chili was treated differently than another group. And what he does is he says everyone who films law enforcement is treated poorly, which is the absolute wrong argument. In addition, plaintiff repeatedly pled allegations that this targeted enforcement, i.e., everyone who does exactly what plaintiff did is treated exactly the same way as plaintiff, produced a chilling effect on First Amendment rights of the press in contravention of the First Amendment of the United States Constitution. Under Rule 12b6, it suffices to meet the notice pleading standard. So I guess we've moved, but again, the problem is that, thank you, Mr. Caruso. Mr. Caruso. Again, the GLICS is you have a right to film public officials in performance of their duties in public, subject to reasonable time, place, and manner. Blah, blah, blah. If the court is inclined to review the body-worn camera footage in this case, the court will note that many citizens walked just as close to the, quote, investigation scene as plaintiff Decastro was during the alleged traffic stop. Oh, but see, there's a difference. They walk close, right? But do they interfere? Do they start talking to Chili? And how close do they get? Chili was within like 5 feet. Are citizens going to walk just within 5 feet? Are those citizens moving through the zone, or are they stopping there? These are differences. And this is interesting. Now he's actually referencing the body-worn camera footage. So where it helps him, I guess he's going to reference him. So does Chile want the court to review the body-worn camera footage? In one instance, a citizen walks directly up to an officer to ask about the open or closed status of the restaurant abutting the investigation. Well, do we not see a difference there? Can I go in there? Or is that blocked off? He walked up to an officer. Did he walk up to Chile? Is there a difference there? I think there is. Excuse me, officer. I'm trying to go to the restaurant behind you. Is it open? Can I get through there? I don't want to disturb your scene, officer. Can I go there? I think there's a bit of a difference. If Decastro's mere presence, it's just mere presence, and recording, it's just presence and recording. It wasn't the other stuff. It's just presence and recording of the initial stop was obstruction because of his mere proximity to the investigation. Why were these other citizens not even warned to get away from the scene? The answer, as pled in the complaint, is selective and discriminatory enforcement. But were these other people recording? The recording is the First Amendment activity that you're alleging. You're alleging I am engaged in a First Amendment activity and I am being selectively enforced against for my First Amendment activity, i.e. recording. Which one of those other people was recording? Oh, they approached. Is that recording? No, it's not. So hopefully Woodinville? Is Woodinville good? You know, the weird thing about bourbons is that everybody has their tastes. Everybody likes different things. You know, you can't I remember when I first came into money. I mean, you know, first year family law attorney money, and I bought a bottle of Whistle Pig, which is a, you know, it's one of the bourbons that they keep in the locked section of liquor stores and things like that. And it was expensive. I don't know exactly how expensive. It was expensive to a first year family attorney. Maybe it's not expensive to you. And I tried it and I did not like Whistle Pig at all. And it's considered a high-end bourbon. You know, I'd rather drink Jim Beam than Whistle Pig, to be honest with you. You know, Jim Beam isn't a high-end bourbon by any stretch of the imagination, but it's a good solid all-around bourbon. Way better than Whistle Pig and less expensive. That's weird. Why does his pleading lines only got down to 26? You know what bothers me? And I spent a long time working on my pleading paper to make it correct so that my one there matched up and that my spacing was absolutely correct so that you could instantly tell. You don't have these like half lines where is it 25 or is it 26? Oh, I fucking hate that. I'm not a Scotch guy. I've never really liked Scotch. Yeah. I don't know why, but you know, everybody's got their own taste. I don't know. I'm not I don't drink enough to really know what to look for. I just know it tastes good. Oh, this one tastes good. Jim Beam is good. Wild Turkey, I've had a bad experience on Wild Turkey. So, oh well, congratulations, Philip. Congratulations. Stay strong. No, new. I watched that. What's his name? something Van something. Anyway, like what is he? Sommelier, and he drinks a bunch of different Malort concoctions, and they're freaking terrible. All right. Anyway, so back to the topic at hand. He's played that similarly situated individuals at a similar distance were not treated similarly in the First Amendment act of filming. In this case, did not obstruct the officer's duties. Again, that's not relevant. It wasn't the filming that he was arrested for. Plaintiff has alleged Officer Bork engaged in profiling against members of the press by stating First Amendment orders, blah, blah, blah. In other words, Bork operating on the presumption that citizens who film law enforcement present a higher danger. Yes. So again, that goes in the face of his different treatment. Well, not anymore because you gave up drinking, Mr. Jackson. So stay strong, buddy. Southern Comfort is a problem because Southern Comfort with a splash of sour, and I can't tell I'm drinking alcohol. So I don't fuck around with Southern Comfort. I remember back in college, I drank so much Southern Comfort in one night. It was a problem. It was a problem. And so I don't fuck around with Southern Comfort anymore. In addition, plaintiff repeatedly pled allegations that this targeted enforcement produced a chilling effect on the First Amendment rights of the press in contravention of the First Amendment to the United States Constitution. So the problem with this is Chili's actually going to have to compare himself. If he's saying I'm a member of the press, he's going to have to compare himself to other members of the press, right? And the problem for Chili is all of the news reports out there where other members of the press have recorded traffic stops, have recorded police interactions, have recorded arrests. You know, News 5 on the scene at a shooting, blah, 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 right? And what do the other members of the press do? They stay on the opposite side of the barricade. They move back when the officers tell them to move back. So if Chili compares himself to other members of the press are allowed to record police interactions, subject to reasonable time, place, and manner restrictions. This is a terrible argument. Like, he's not wowing me with his argument, but you know, there might not be a good argument to make, unfortunately for him. So we're going to move on past this because he's not going to go anywhere on this one. Plaintiff has identified a constitutionally protected activity. So any of these qualifies immunity arguments are inappropriate under 12b6 framework. Why is it? Why is it inappropriate to do a qualified immunity argument under 12b6? He doesn't say. Second, he's identified constitutionally protected activity acknowledged in the preceding case, which is violated in law. Nevada's obstruction statute must end where constitutionally protected conduct begins. If filming law enforcement in a public place is protected by the First Amendment, it cannot be, by definition, obstruct any lawful law enforcement conduct. Well, if it is protected by the First Amendment, and it is, subject to reasonable time, place, and manner restrictions. Yeah, it's a problem. It's way too drinkable. You know, I will confess I like to have a glass of bourbon every now and again. I guess that makes me an alcoholic. I probably drink more than what Coded would approve of. But yeah, I mean, like with bourbon, you could take like a little bit and, you know, I add ice and water and you could sip on it for an hour or two, and you get the flavor and stuff, and but SoCo, boy, you add a little sour to it, and man, it just goes down quick because it tastes good, like drinkable good. You want me to manhandle you? Well, don't mind if I do. No suggestions like that. We're not making suggestions on things that make Southern Comfort even more drinkable. Therefore, there is no such thing as a criminal obstruction of a law enforcement officer's unlawful command to stop filming or to go back to a distance beyond what is protected by the First Amendment or any combination of these protected activities. So right here, Meat gives it up. Right here. So on the rocks, let it melt. That's great. Here's the problem. I like to drink more. I can enjoy it with melted ice, yes, but I prefer to actually add ice and water, because then it doesn't take a lot of the flavor to really. I prefer it with water. I almost exclusively drink it with water. I'll, enough bourbon in there to give me the taste, and then ice, and then the rest filled with water. And I just really enjoy it that way. I love the flavor. But yeah, he gives it up. He acknowledges that there is a distance that they can make him back up. Regardless of whether or not law enforcement ever developed grounds to arrest plaintiff during this underlying event, they violated his First Amendment right when they ordered him to cease engaging in a constitutionally protected conduct. I think they told him to back up. Yeah, that's my memory of it too. But again, I guess it would depend on what the pleading says. Well, as clearly established in the Ninth Circuit, there's a right to be free from retaliation, even if the officer has probable cause to arrest. See Skoog. A reasonable officer would have known he cannot retaliate against a citizen for recording police in a public place, even if the officer was also acting to protect the safety of officers or to arrest her based on probable cause. See McComas. In Fordyce, the New York held that citizens have the right to film matters of public interest. A genuine issue of material fact exists because Fordyce testified the officers deliberately and violently smashed his camera into his face when he was participating in a protest and gathering information. Yeah, but see, he wasn't doing things like interfering with a police stop. In the decades since Fordyce came down, district courts in the circuit have continuously recognized a clearly established right to peacefully film police officers carrying out their duties in public, subject to reasonable time, place, and manner restrictions. A reasonable officer in defendant's position would have known that it is a violation of a constitutional right to harass an individual who's peacefully filming the officer. Thus, under the law of the circuit, there is and was, at the time of defendant's conduct, a clearly established right to record police officers carrying out their official duties. In light of Fordyce, no reasonable officer under the circumstances would believe the defendant's alleged actions were lawful under the First Amendment. Here, plaintiff has pled numerous violations of his First Amendment rights. To be clear, the following separate violations are pled. Defense unlawfully ordered plaintiff to back up when the distance from which he was filming is protected by the First Amendment. Your right to be someplace is not protected by the First Amendment. No disrespect to Artie, but I don't watch him. I'm sorry. You don't have your mom vacuum your room? Oh, I gotta go. I gots to go. It's been real. It's been fun. I wish I could say it's been real fun.